Welcome to Tech Intersect. I'm your host, Tanya Evans, and my life and work exist at the heart of law, business, and technology. Yeah, I've earned a few fancy titles and degrees over the years, but the bottom line is I'm a writer, speaker, teacher, and lifelong learner, and I'm really excited that you've joined me on this journey. So what is Tech Intersect? Well, it's authentic, empowering conversations with really interesting guests who demystify complex topics to prepare you for the future. Because your future is now. And it exists where law, business, and tech intersect. Get ready to listen, learn, and leverage. Let's get started. Hey, everybody. In this episode of Tech Intersect, I welcome intellectual property attorney JoAnn Holmes. Jo practices law in the areas of digital assets and intellectual property licensing. She works with innovative clients to protect and monetize Web 3.0 and metaverse digital assets such as cryptocurrencies, NFTs, and blockchain technology. And during her career of more than 20 years, Jo has managed IP generating over $2 billion in annual revenue. She's successfully negotiated lucrative licensing deals with companies such as Disney and Microsoft and the NFL. And she currently manages legal rights for brands, software, and creative content spanning more than 125 countries. Jo has served as an adjunct professor of IP law, written for the American Bar Association, and hosts her firm's podcast, Your Business Ally. So please subscribe to that ASAPidly. I feel like I've met my professional doppelganger, and I'm really excited to share this conversation about how to protect and manage your intellectual property, especially trademark. Now, this is an issue that's come up a lot recently, the misappropriation of brands and brand names in the metaverse world, in the Ethereum name service or ENS domain world. So we're going to talk about that and more at a high level in this episode, and then we will continue to take deeper dives in successive episodes based upon your questions. So be sure to follow both of us on Twitter and on LinkedIn. Check the show notes in order to connect. Now, if you tried to figure out crypto, DeFi, and NFTs on your own out there in YouTube or Podcast University, I invite you to go a different route because I've worked hard so you don't have to in order to make this all make sense. So visit advantageevans.com to learn how to buy and store and trade crypto and NFTs and access DeFi safely, legally, and confidently. Advantage Evans Academy offers prof-guided on-demand and cohort-based courses, as well as an engaging, informative, and really fun membership club. AE Explore Live, we just launched back in November. We meet once a month and have special meetups and exclusive content. So you can join as a quarterly member for as little as $99 or $1 a day. $365 will get you an annual subscription. Head on over to advantageevans.com to learn more, and I look forward to seeing you at a future session or meetup. I'll help you transform your relationship with money, generate wealth in the new digital cash economy, create digital ownership streams that lead to generational wealth, vet, buy, store, trade, earn, and sell cryptocurrencies, engage in DeFi and lend and leverage your crypto, and create, buy, and trade creative and collectible NFTs and more. We do all of that in a wonderful community of like-minded, lifelong learners ready to get in and win. If that sounds like you, join us. Visit advantageevans.com to get immediate access to resources and our session schedule. Before we hop into the episode, please take a moment to follow this podcast and then like, share, and comment so that others who would benefit from this content can find it. Okay, it's time to listen, learn, and leverage. Let's get started. In this episode of Tech Intersect, I welcome intellectual property and technology attorney JoAnn Holmes, Esquire, to the show. Jo is an attorney who practices law in the areas of digital assets and intellectual property licensing. And she works with really innovative clients to protect and monetize Web 3.0 and metaverse digital assets such as cryptocurrencies, NFTs, and blockchain tech. And I invited Jo on to talk about how best to educate and prepare creatives and entrepreneurs not only to survive, but to thrive in a Web 3.0 world where ownership and control is fundamental and essential. It sounds simple, but it's far from easy. And we'll talk about all of that and more in a moment. But first, Jo, welcome.
Thank you so much for having me, Tanya. It is a true honor to join you.
So I'm so excited. We have connected and you broke all of the rules with my rule, #NoNewFriends, because not only are you a wonderful colleague, but definitely I consider you a friend. And I look forward to nerding out with you on this episode and continuing to build with you because I finally found my tribe and
Yes.
found you in the space. So why don't you, before we get into the meat of some of the things that I want us to discuss in order to help empower and protect creatives and entrepreneurs in this Web 3.0 wild, wild west. But first, share with the listeners your origin story of how you prepared yourself for such a time as this at the intersection of intellectual property and technology.
Well, thank you. So I've practiced intellectual property law with a focus on global asset management and IP licensing and monetization for over 20 years now. I was fortunate that I started my work in 1999, right at the cusp of the internet age. And so I was a baby lawyer coming into technology practice and looking at commercialization on Web 2. And I didn't really have any point of reference. So my entire legal career, I have been protecting trademarks and copyrights and trade secrets with an eye towards not only their global impact, but their presence on the internet, which innately makes them global. I've had the great fortune of working with clients from entrepreneurs and startups to multi-billion-dollar companies, negotiating deals with companies like Disney, the NFL, DreamWorks, and Sony. So what I say to people is that the words intellectual property might be intimidating, but we all engage with IP every day. And now my practice is IP for Web3. And I'm super excited because what this is going to create is an opportunity to grow more egalitarian IP-based wealth.
I love that you say it that way because that's one of my greatest joys in operating in this space and helping to empower folks to really understand and appreciate the nature of their intellectual property rights. We already know how important it is today and how important it was yesterday, even more critically important as we continue to move forward and metaverses are being created and folks are, sticking their flag in the next the next iteration of property and digital property in particular. But some of the things that you and I continue to talk about are the fact that the rules still exist. It's not that these things are being built in a vacuum, that we have intellectual property rights. And let's even define what that is before we move forward. We focus on the big three. Obviously, there are a lot of different areas, even beyond copyright and trademark and patent when you think of right of publicity and some of the other things. But let's focus on the big three this time. And maybe we will make this a series of conversations because there's so many things to talk about. How do you explain the differences between the big three, copyright, trademark, and patent?
You love listening to podcasts, but have you ever thought about starting your own podcast? Maybe you want to build a brand, grow your business, or are looking for an excuse to talk about your favorite hobby. Whatever your reason for making a podcast, Buzzsprout is the place to start. Since 2009, Buzzsprout has helped over 300,000 people launch their own podcasts. Buzzsprout walks you step by step through the whole process and will give you powerful tools to start, grow, and monetize your podcast. Ready to get started? Click the link in the show notes to get our free step-by-step guide to starting your podcast today.
So trademarks are going to be things like brands, logos, and slogans. So an easy example is Nike is a brand name. The logo is the famous iconic swoosh, and the logo is Just Do It. Copyrights are I break them down into creative copyrights and business focused copyrights. And so
Mm.
if we think about creative copyrights, they're going to be things like film, books, music, artwork. Business focused copyrights are going to be things like training materials, the things you use for your presentations, the videos of those assets, all the types of things that a professional or a consultant might go into a room and use to be able to present and reflect their expertise. Patents are typically going to be in the guise of things that you would categorize as useful and novel inventions. So, an old school patent that we use every day is a light bulb. A new school patent is the technology that makes our smart lights work.
That's really important that people understand the nature of the assets. I see so often in Twitter Spaces and all of the other social media outlets that there's a lot of lawyering going on by folks who aren't lawyers. And anytime you
Indeed.
enter one of those spaces and they say, I'm not a lawyer, but I want you to hit the button that says leave. And then I want you to follow Jo on Twitter. I have all of her information in the show notes. And certainly for me, because it's critically important to understand the nature of your rights and then to figure out how best to protect them so that you can monetize them for the life of that intellectual property, right? In a previous episode of Tech Intersect, I've broken down copyright as being the right to copy or the right to distribute those copies, the right to adapt or prepare adaptations or derivative works. A lot of people talk about that as well. Public performance, public display. Far fewer people are actually talking about trademark. And I want to spend some time at a high level in this conversation with you about some of the issues, certainly copyright, anything that you want to talk on that side, but also in particular now that folks are exploring, as you said, either logos or phrases or words, a series of words, a sound that is connected to some type of monetization, right? Or commercialization so that a person can identify that they're going into McDonald's instead of McDowell's, right? For example.
You went old school, Tanya.
I went all the way back. I went all the way back. So bring us current and let's talk something about the trademark phenomenon, particularly because we have these Ethereum name service domains or ENS domains that are really, really popular right now. And there's some funny business going on there with some cyber squatting. But let's begin at the beginning and talk a little bit more about trademark.
Sure. So in the United States, we have a concept called common law, and we also have the statutory and regulatory ability to register trademarks. So let's say you're a mom and pop restaurant and you sell in your town. Everybody in your town knows that this is the name of your restaurant. You may not have a need to either at a state or federal, or for that matter, consider protection in various countries for international trademark rights. You can just rely on those local common law rights because people know the name of your restaurant. But if you're going to sell outside of your local jurisdiction, then you want to think about protecting your investment. And one of the ways that you do that is through registering your trademark either at the state, federal, or international level. State trademark registrations are going to be, as you would imagine, if your plan is only to use your brands, and again, when we're talking trademarks, we're thinking of brands, slogans, and logos, if you're going to use those only within your state. But because most businesses are going to have a presence on the internet, you might have folks who want to buy your products or services throughout the country or even outside the United States. And that's when you really want to start looking at federal trademark protection. That's done through the US Patent and Trademark Office. But what I always advise clients to do is step back and really try to be defensive before you're offensive. And what that means is looking at doing trademark clearance work. So if you want to save some money, you can literally start off by doing a Google search and typing a search for the brand name you want to use and the types of products or services that are in your industry, and see who's out there, see who has websites, see if any social media accounts come up on Facebook, Twitter, Instagram, even TikTok for for that matter.
Mm-hmm.
What you're trying to do is get a handle around who's out there using the same, or what we call is a term of art, a confusingly similar brand name.
Mm-hmm.
And then once you've got some confidence around that, if it's an important brand to you, if you're going to start spending any kind of substantial money on marketing, then you'll want to speak to a trademark attorney to help you through the process of getting a federal trademark application in place. Once that happens, an examining attorney will review your application. You'll go through sort of a process of looking at what other trademarks exist on the Federal Trademark Registry. And if that examiner approves your application, you've got yet another hurdle, which is anybody who thinks that your trademark might infringe their rights can challenge you. But the good thing that comes at the end is if you get that registration, then you have got a presumption that you own that trademark in connection with your set of goods and services throughout the United States. Then you kind of go on the offense. And what you can do with that trademark registration is stop others from trying to use your same brand or a brand similar to yours. One thing that might be confusing to folks and might be a helpful reference point as they're getting started is that trademarks identify a specific set of products or services. And that's why we can have Delta Airlines, Delta Faucets, and Delta as the name of a sorority. That's because they're all identifying different products and services. So you really want to think about and get protection for your brands. Again, remember that's going to include your slogans and logos for your set of products and services.
That's so helpful. And I think that when folks are iterating and, it's like move fast, break shit, figure the rest out later. Excuse my French. I know my mother listens, so sorry, Mom, but it's the point. It's literally what innovators say in this space. So I'm
it is indeed. I verify for her, Mom.
Thank you, Jo. But that's problematic in a space where it collides with the requirements of intellectual property generally, and what we're talking about for this episode today, really focusing on trademarks. And so you've highlighted very well that just because you are innovating, or maybe folks are trying to stake their mark on the next proverbial moon here, which is Web3 or ENS domains, that if you are intentionally registering the trademark of someone else to kind of wait it out until they contact you and say, hey, that's actually my name that's now just not used to identify me, but to identify, the Oprahs of the world. Oprah's name just doesn't identify her as a person, which in and of itself would not be registrable, but identifies that people have come to know that as a business, as an enterprise, as a service that is uniquely connected to and delivered through Oprah Winfrey in particular. And certainly Harpo, for example, would identify specifically her company, and it is used to distinguish and then to build the goodwill of a name and a reputation, but also to avoid the likelihood of confusion so that you wouldn't go there, something that looks not only either the same or similar, and that you would, as a consumer, misunderstand or be confused. Now, there are a lot of different ways to even create a trademark. So not all words or logos or phrases will function in the way that you've described, right? So there's certain words that are just generic, or things that are merely descriptive that don't uniquely identify the source of a particular good. And then we get up into the great categories that we love, that have what we call inherent distinctiveness, either suggestive or arbitrary or fanciful. You want to talk kind of at a high level to help people even figure out, when I come up with my name for a particular good or service in Web3, how do I know when I can go from some common law right because I'm using it actually within, a state, for example, to go beyond that to have protection throughout the United States. And we're focused specifically on U.S. law right now. Maybe we'll do something later from an international perspective. I know you have some things about the frustration of registering something here in the States, but not having one place to register and protect you throughout the world. That is somewhat problematic. But talk to us about the strength of trademarks.
Sure. So the purpose of trademark law is to avoid confusion. And if you think about that as a business owner or an innovator, you are spending your time in marketing and selling and providing a quality product or service because you want the public to come to associate your brand with that quality product or service. Part of what you want to do is create brands that are going to stand distinct from generic terms that identify the underlying product or service. So let's use an example. If you create software and the name of your brand or your service is code, well, that's not going to distinguish your product or service from others because software is code. Those terms are synonymous with each other.
Mm-hmm.
However, if you are a computer software company and you are innovating and you decide to call yourself Apple, there's no association between the word Apple and computer software until the public is educated through your marketing and your service offerings around that Apple brand. And that is why Apple is such a strong brand. So there are a spectrum. We as trademark lawyers think through the strength of a brand by looking at a spectrum of, is it generic, like code for software? Is it distinctive? Is it, as you said, going to be arbitrary? There's a spectrum through which we are doing that analysis. Mm-hmm. But if you are a business owner, a brander, an innovator, ultimately what you're going to most likely want to do is find some common ground between a term that is going to convey the quality or a positive attribute of your product and service, but have it be unique enough that it's not going to be immediately descriptive. Right. So if you are, let's use another example, MailChimp, you are completely innovating there because that has nothing to do necessarily with the underlying set of products and services. This is how we come up with things like Uber, again, for ride sharing services. There's no immediate connection. And the people on your marketing team are going to push back a little bit when you're doing that kind of innovative branding because they're going to want some kind of association. The prize, if you will, at the end of the work that you've done is when you've marketed and educated your buyers around your brand, you've got a super strong brand and you can block out others. One thing to keep in mind is if your brand is not only strong as a trademark, but then it becomes famous, you get an additional set of rights. So going back to Oprah, while your name alone, I can't necessarily go out and get a trademark for JoAnn Holmes for being Jo. But what Oprah has done is she's actually built a famous brand. Started out with her television show many years ago, the Oprah Winfrey Show. But then because of the fame of that brand, she actually built what's called a family of trademarks, which makes her brand particularly strong because she has got, licensing that expands from the original media assets with her magazine, her own network, with her Weight Watchers deals, her deals with Apple. So she's built out a family of brands. If we take this and we consider it in the guise of blockchain technology, there are lots of really early innovations happening right now. So we know that Nike has a presence on Roblox. We know that Adidas is looking at spaces in the metaverse. We know that Disney is issuing NFTs. We know that the new Matrix movie that, as we're speaking in real time, is coming out this month, is issuing NFTs. And so all of those have related brands that have been used in what might be considered Web3 or even pre-web ways. So one of the things that brand owners want to be thinking about is, does your existing trademark protection need to be expanded so that you have protection in the new ways that you are using it with Web3 IP?
If you're an engineer or a scientist, you love Formula One, you love cycling, you love learning about how new technologies are changing the world around us, then I thought you may want to listen into my new podcast, the Neil Ashton Podcast. We talk to leading engineers and scientists from around the world, hear about their life stories, hear about new technologies, and hopefully educate you and give you a better sense of how key things like machine learning, artificial intelligence, supercomputing are changing the world around us. If that sounds like it's something you might like, you should come and have a listen.
We hope you're enjoying this edition of Tech Intersect. Our conversation will continue in a moment, but first, a word on an exciting opportunity.
There's a more cost-effective and time-efficient way to reach your leading-edge learning and earning goals, to put you ahead of the stiff competition in this fast-paced, tech-driven economy. You need skills, credentials, and a fast track to a competitive advantage. You need it now more than ever, and I can help. The Advantage Evans method puts you ahead of the curve with condensed, comprehensive online courses, curated content to leverage your current skills and expertise, live coaching, networking opportunities, and more. Upcoming courses include From Cash to Crypto to help you buy your first Bitcoin, and there are 2 ways to get your advantage. Advantage Evans Encore gives you maximum experience for your total competitive advantage and access for 1 year. It includes a live welcome and modules on terminology, buying and selling, exchanges, mining, earning crypto, trading and investing, and also several of the legal issues you need to know in order to be safe and secure as you enter this space. That includes tax compliance, how to plan for a Bitcoin estate, and securities laws to make sure you avoid any legal unforced errors. Now, Advantage Core gives you the essentials. It's a short course to give you what you want and the support you need to buy your first crypto in as little as 3 weeks, with access to the information and replays for 3 months. And if you're not quite ready for your Advantage and want a sneak peek to try before you buy, then register for a free masterclass where I share my Crypto 101 success checklist and cover current hot topics in crypto. So there truly is something for everyone, including you, to get in on the fast track and learn and earn in the digital economy. Visit AdvantageEvans.com to get started. That's AdvantageEvans.com.
And now, back to the conversation.
There's such an important point. There's so many important points, but the one that you made a bit earlier about marketing pushing back, I have had no shortage of battles with clients when I was in full-time practice and even in consulting, wanting to have, the name of their company or of a particular product or service that describes, because it makes marketing's job way easier. If you can identify immediately by the name or the phrase or some other logo design that immediately tells consumers they don't have to do any brain work, they don't have to do any guesswork to immediately identify that, that's merely describing. And so there's this interesting interplay between trademark and First Amendment rights, for example, right? And also this idea that you don't want to have one person or entity that has effectively removed certain parts of our language, or the ability of every business to actually compete fairly, right? Fair competition, great for capitalism. Unfair competition, not great for capitalism. And so the idea that there needs to be enough for everybody to use something that is generic or merely descriptive of goods, separate and apart for something like Coppertone, for Coppertone sunscreen, right? That is suggestive, or an arbitrary mark you mentioned earlier using the word apple, but not to identify literally the fruit, but computers, right? So that's an arbitrary use of a word that exists in our lexicon, or even better, love it all the time, something that's fanciful, literally a made up word, right? Kodak didn't exist in the lexicon until they created Kodak. Now, marketing would scream, because looking at Kodak until they have successfully marketed and staked out their territory, you don't know what Kodak is until they do effective marketing. So it is an interesting interplay, but as a trademark lawyer, if something is arbitrary, fanciful, or suggestive, you know you're going to have a slam dunk when it comes to, as long as you have first use. That's a story for another episode, in terms of using a particular word or phrase or design. So that's the interplay that obviously that requires communicating with a trademark attorney to figure out the win-win scenario for registering successfully, and then also creating a marketing plan.
Well, Tanya, One of the things that you just mentioned is having the fights with marketing. But if we're talking about Web3, who are you actually having that fight with?
Right.
So if we think about assets that are being created in real time, let's say a DAO comes together. What happens? Who controls the IP that comes out of that DAO? Who are
Right.
you fighting with about how you license those assets? Or I think one of the things that's been really interesting to follow, Dapper Labs, as you well know, created the CryptoKitties in 2017
Yes.
and broke Ethereum with that new, what really in our world is an IP asset. And so there were trademarks associated with the term CryptoKitties. There was obviously a copyright in the imagery of that. And then we
Mm,
have these interesting times when trademark and copyright overlap because an image of a CryptoKitty can be a trademark as well as a copyright.
yes.
And so when you have, when you've got the bored apes or the crypto punks that are so popular as NFTs that have been relatively recently, and if we think about the span of IP law, these are relatively new assets for which traditional trademark and copyright law still apply.
Right.
And when you're thinking about application, the thing that I really love to help clients do is figure out, how do you license and monetize those assets? And so, in this Web3 community based new facet of what we think about as IP, which components of those trademarks or copyrights, for that matter, do the original IP creators retain? And which ones do they give licenses that allow the owners of those NFTs to exploit and commercialize? And I think that Dapper Labs did some really interesting things in that facet in terms of, I think it was up to $100,000 that you could commercialize the CryptoKitties. I know I recently heard one of the creators of Axie Infinity talk about how they are figuring out those IP ownership and licensing issues right now. If you are an Axie owner, which is effectively if you are an owner in one of those NFTs, what set of IP rights, what set of trademark and copyright rights, to be more specific, are the Axie Infinity creators and owners going to retain versus which ones do they let their NFT owners commercialize? So there
Mm.
are some really interesting new issues that are arising by virtue of Web3 and metaverse assets.
Yeah, I'm really fascinated by that because there's this combination of existing intellectual property laws married to the terms and conditions of use for these minting platforms that assumes that you're using a minting platform, and presumably someone
Yes.
could create their own NFT and do a peer-to-peer transaction, which is Satoshi's dream, not on the NFT space,
Mm-hmm.
obviously, but to the direct. But so many obviously are using minting platforms. And so having an appreciation for the terms of service for those particular platforms, and then also knowing how those assets are being memorialized. Is it a centralized memorialization of that referenced asset, right? The URL that's connecting somewhere that is centralized, easy to take down versus something like on IPFS that is not, which is another interesting thing. And also, I'm putting that on our list of things to talk through. I feel like we need to do like a series, like once a month, we need to get on and actually do this because I'm looking at my time and I'm mortified because I have millions of things. But I wanted to ask you this as well, Jo. So I saw a project. Let's start naming projects. I saw
Sure.
Lego Punks, and I was like,
Mm-hmm.
Lego Punks. Oh, cool! Lego's getting into the NFT game. That's super smart. And I go and I was like, oh, there's only, I don't know, it's like 1,300 followers at the time and maybe 1,400 now. That doesn't sound like Lego level. I'm wondering if Lego's
Mm-hmm.
actually involved because as a consumer now I'm confused and I'm interested in a project that is connected to Lego. But if it's a project that's using the Lego famous brand, but not affiliated with Lego, that's going to be problematic. So the lawyer in me reached out to Lego and I wrote them. I DM'd them actually. I don't know about writing, but I DM'd them and I said, hey, Logo, I see this awesome project called Lego Punks. Is this the official Lego brand connected to this NFT project? And if not, it seems confusingly similar, but let me know because, I'm an egghead IP lawyer and professor. And they wrote me back and they say, And I'll put a link in my show notes to this. Hello there. Always awesome to hear from our fans. So that's probably a bot. I don't know. But it
Good chance.
says, right? But the rest of it is quite interesting. It says, and I quote, "We can confirm that the page that you're referring to, and it's on Twitter, is not affiliated with the logo group in any way. There are currently no plans for us to engage in anything like that at the moment. We don't have any further information about NFTs at this time, but the future is full of possibilities." And you'll have to keep a close eye on our social media pages to see if anything changes in the future, and then some eyeballs. So that's clearly a low-level social media manager responding, but I'm thinking that the IP department, or they probably already know. And it's interesting to see that response. So the short answer of no, we're not connected. But then also, sometimes famous brands are going to let it ride until they figure out what to do about it. And so I'm wondering about your thoughts, if you're representing a famous brand, how to navigate this space, because this is popping up every single day.
So one thing that I would caution folks, and there's a balancing act, because in a new space, there is certainly a school of thought that, any publicity is good publicity. You want to have fans show their interest in your brand online. And that's one way of thinking.
Right.
Another way of thinking is that when you are a brand owner, you have an affirmative right to police and protect that brand.
And a duty.
So anyone who's exactly, and a duty. And so one of the things that anyone who is considering creating a fan art or a famous brand related presence online, certainly if you're going to be commercializing products or services in that vein, you should expect that sophisticated brands will be employing software where they are regularly searching the internet and being made aware of how not only their brands, but similar brands to theirs are being used. And that could result in a cease and desist letter to the extent that you can identify the person or entity who is trying to capitalize on your trademark rights. Another way to think about this, and if I were advising a famous brand, I would say, you need to be proactive. If we think back again to the early stages of the internet, we went, and I'm borrowing from Chris Dixon here, that we went from Web 1, which was read, to Web 2, read, write, to Web 3, that is read, write, own.
Yes.
And the anticipation is that Web 3 is going to be participatory. It's going to be collaborative. And we're not going to have centralized organizations that set rules that tell people how they can interact with each other, nor how they can interact with brands. But we understand that under the guise that existing intellectual properties law still exists, and they should, because we want to encourage and reward innovation. So the thinking around this is that just like when social media came about and brands were trying to figure out, should we have a presence on these platforms? Well, if you don't, both your fans and your detractors are going to be on those platforms. If you are not policing your brand presence on the internet, then both your fans and your detractors are going to be present. And so you need to have a proactive strategy. Again, what I love to do is make deals and monetize brands. And so what I would think about is, what are these folks with the Lego punks doing? Are they doing something new or innovative? Is there an opportunity for us to partner with them? Because what you've got to be mindful of is everyone has a megaphone online. And so if you take too heavy a hand, then what can happen is a blowback. And if there are opportunities where you can protect your IP, but also look at innovation that's happening and think about ways that you can partner, think about ways that they could potentially be a vendor. I haven't seen this particular example, but there's a lot of creativity happening, and not everything can happen in-house within your organization. So have a proactive strategy where you are huddling marketing, your social media team, your legal team, your innovators, and thinking proactively around what is an acceptable use that will maintain and protect and police your trademark rights? How can you engage with those who find value in your brand? And how can you shut down what's going to be detrimental? But it's got to be a delicate touch. It's got to be bespoke, because a heavy hand and a sledgehammer with every one of those things is not going to be the right touch.
I think that is precisely spot on. And this is why, for all of you listening, you need to tap into Joe Holmes and really arm yourself with the best team possible to figure this out. It's great if you're moving fast. It's great if you're breaking things and then retooling. But if you're doing that without tapping into legal early, often, and in between, you're doing a grave disservice. You're throwing good money after bad, and you're going to call us sooner or later. But later's prices are higher than today's prices, and yesterday's prices, forget about it. So Joe, share with the listeners how they can get in touch with you and continue to learn more about you and your work.
Well, thank you again. It has been such a true honor and privilege. And I want to say thank you for the work that you have done in this space. Representation matters, and you are doing excellent work educating and representing and showing what is possible, including to me. So thank you for your example. I would encourage folks to definitely reach out to me on the ideation side of things, because what I love to do is make clients money rather than fix problems on the back end.
Let's go.
I am on LinkedIn. I'm active there, engaging with folks in the Web3 and blockchain technology space. My website is Holmes, like Sherlock, at law.com. My Twitter handle is also Holmes at Law. And I have to tell you, Tanya, like I literally, I'm listening to podcasts, watching YouTube videos, speaking to other attorneys, speaking to people in the finance and accounting space. I can't absorb enough of this information.
Right.
It is the most interesting thing happening in intellectual property. And hearkening back to the beginning of our conversation, talent is indiscriminate. If you have talent as a creator, as a brand, you have a brand that has a following and a community. If you are an entrepreneur or an established business, everyone needs to have a strategy in this space. This is the next turn of the web and internet technology. And I'm just giddy about working with folks to see what we can do with it. All over the world, this is creating opportunities in ways that didn't exist before. And so thank you again for the work you're doing. And I invite folks, let's be friends. Let's learn about this space together.
Thank you so much, Joe Holmes, for sharing so much insight and expertise in this wild, wonderful world of intellectual property at the intersection of technology. I look forward to making this a regular part of Tech Intersect. And listeners, if you'd like to hear more of this, tag Joe and I in a tweet and let us know. Now, if you've learned nothing else from this episode, please know that digital ownership in today's Web 2 and tomorrow's Web 3 and beyond is critical to success as a thriving creative or entrepreneur. Your plans, your vision, your creations are absolutely nothing without a clear, focused, and well-managed IP portfolio. If you think it doesn't matter, then ask those people and brands whose IP is at risk or compromised because someone else beat them to the punch. And if you're buying up the metaverse real estate or trying to stick IP holders for their Web3 domains and properties, especially famous brands, you better lawyer up, Buttercup. The public permissionless web makes it much easier to identify registrants, and cyber squatting is illegal. Now, that doesn't mean it's equally easy to enforce rights in a court of law or even figure out the jurisdiction or who to sue. But in those Twitter streets, it's shock and awe once you're identified as an ENS cyber squatter. And finally, for all of you brands, famous and otherwise, hashtag Lego. If you listen to the episode, you know what I'm talking about. Decide how and when to enforce your marks against Web3 interlopers. The strategy that all publicity is good publicity may endanger your exclusivity and empower others to free ride off of your goodwill and confuse consumers. Let the trademark owner and the pirate beware. Before we sign off, please take a moment to like, comment, and share this episode and this podcast with your networks. Follow me on social medias and let me know what topics you'd like to hear more of and who you'd like to hear from. All right, that's all for this episode. Until next time, continue to shine.
Stay in touch with host Tanya Evans via your favorite social media. On Twitter at TechIntersect. And on Instagram via the handle TechIntersect. This podcast has been produced by Stephanie Renee for Soul Sanctuary Incorporated.